Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within and for the Commonwealth. Draw near, give attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated. Good morning. Welcome to the Appeals Court. I'm Justice Mead. With me on the panel today are Justice Ditkoff and Justice Toon. The only case we're hearing today is the first one. Each side gets 15 minutes. You needn't use all your time. We do not entertain rebuttal. With that, we'll get right to it. 24P 1073 HSBC Bank USA versus Mary L. Morris and another. Mr. Morris.
Good morning, Your Honors. I am under order not to argue today. When the court knows that I have found a lawyer to argue for me, but this date was not enough time to prepare. The court ordered that this hearing must go forward today. It cannot mean the court does not want to give me a full and equal hearing, especially for taking my property interests, both the title that have never been sold and my right to live in my home as an 85-year-old disability person who have decided, who have a decision from the SJC which reversed all the judgment in this case. Now that my wife, 81 years old, as I trust the court does not want to treat our life by putting us in the street. The shelters are full and the housing is short. I am invoking my rights under the American with Disability Act to have assistance of someone else in completing this argument. Now I have part of this is going forward today by the art of a lawyer, but he cannot be hired by one, nor existed trust as two. The plaintiff with no signs found documents in the Registry of Deeds as evidence shown. I apologize, Your Honors. I mean, I'm not a speaker, period. So if any misrepresentation, I hope
you're doing fine, Mr. Morris. This is your third appellate argument that you've represented yourself in, which is more than most lawyers do in their career. So you're doing just fine. So go right ahead with the merits of the case.
Okay.
What is it you'd like us to decide?
Sir?
There's some issue about the remand, right?
Yes.
And the SJC's decision that you have argued that you're entitled to possession, and the bank or the trust says otherwise. And can you speak to that?
Well, I was ordered by my doctor that I should not be, I am under a doctor's order not to argue today. When this court knows I have found a lawyer to argue for me, but this date was not enough time to prepare. the court ordered that this hearing must go forward, it cannot mean that.
Well, this matter was originally scheduled to be heard on November 13th at the University of Massachusetts at Amherst, and you asked us to reschedule it
Yes.
to be held here, and we granted that motion.
Right.
And then we offered to further accommodate you, so you wouldn't have to even drive to Boston, that we would hear the matter on Zoom. And you asked us not to hear the matter on Zoom, that you wanted to come here. And then by agreement of the parties, we picked today's date that you had agreed to, and the trust did as well.
Okay. Well, Your Honor, we put an affidavit. I put an affidavit to cancel this hearing because I wasn't in a condition to be here today. Okay, and I had a court order. I mean, my doctor's here order, and I'll tell you, I couldn't have made it here. I have two assistants up there to help me because if I had to come here today by myself, I never would have made it in this courtroom because I can't come up those stairs and stuff with this stuff. So I put in the request. I requested this hearing be canceled for a later date. I'm in a better shape than I am today. And I had asked the court, but they denied my request. So I'm trying to do the best I can.
Okay, go right ahead.
And but the point is, like I said, my doctor instructed me to, not to argue, because I have an attorney to argue before me, because on this case, I had 4 lawyers was on this case, and the court let all of them walk away, and I had paid them, so I don't know exactly what else I can do. And if I may have Ms. Ross to speak on this behalf.
No, Ms. Ross is to my knowledge, is not an attorney and does not have an appearance in this case, so no.
Right.
Is there anything else you'd like to tell us?
No, I have nothing else.
Okay, thank you. We'll hear from the trust.
May it please the court, Jordan Schur from Hauser LLP for the appellee. I know your honors are familiar with the case, so I'll be brief. The entire position of appellant is based on a misconstrual of the SJC order. The SJC order clearly states that only the PHL PA counterclaim survived. It therefore remanded back to the housing session to adjudicate the court with only the survival of a single counterclaim. The other defenses and counterclaims were struck. The judgment stayed intact. The order is clear. The case was remanded. The housing session, to clarify this, allowed parties post-remand briefing to narrow the scope of the issues.
Well, so normally when I see a snapper, it says this is reversed, otherwise the judgment is affirmed. But I don't see that in the SJC snapper. It tells me what's reversed, but it doesn't say anything about anything being affirmed. What am I missing?
It does narrow the scope of the reversal to reverse in part. SJC held the counterclaim may be asserted for, it was very specific. The counterclaim GLC 183C can be asserted, and thereafter the housing session held at summary judgment, issued a decision in August 2023. This is a loan that hasn't been paid since 2008. There's been 17 years of free living.
But getting
for the
back
mortgages.
to Justice Ditkoff's point, the relief in the SJC's decision does not say that the judgment is infirmed in part, reversed in part. It just reverses on the PLAPA claim, right? So you assert in your brief that the SJC affirmed the housing court's judgment for possession in favor of the trust. But I've read this opinion now many times, and I don't see that. So that's one issue as to whether or not there actually is an affirmance of the judgment for possession, or is it all bound up with a summary judgment ruling that involved this one counterclaim that you recognize was sent back? And the other issue is, was that counterclaim handled consistently with the SJC's decision? Because they said in the footnote, you know, the Morrises may pursue damages even though there is not presently a claim by HSBC for the deficiency, right? It goes back to a housing court judge, and the judge decides, well, there's no claim for deficiency, so therefore I'm going to reject the claim. That doesn't seem to be consistent with what the SJC said in that footnote. So those are the two issues I think that we want you to address.
Sure. I think we'd all agree the SJC decision could have been written a little more clearly on what they were directing. But I think that if you read the briefs and the entire focus of the argument, they do very specifically specify which counterclaim is being remanded. And they left the rest of the decision undisturbed. And then to your second point about the actual counterclaim itself and evaluate, there's no claim for monetary damages by the plaintiff. They're not very explicitly have said they're not seeking a deficiency judgment. And therefore, although that type of counterclaim is permitted to proceed post-foreclosure in an eviction capacity, I guess, it's not relevant because even defendant has admitted the plaintiff is not seeking any monetary damages.
But what do we make of the Supreme Judicial Court's statement that the Morrises may pursue damages sufficient to extinguish their deficiency on the loan, even though there is not presently a claim by HSBC for the deficiency?
I think that was leaving the door open in case my client ended up seeking a deficiency judgment, because at the time of the SJC argument, we weren't, and we're still not today. And
Did your client ever disclaim it, though? What's to keep your client from asking for the deficiency tomorrow?
I don't know that they're legally not. I mean, they've put in writing that they're not seeking deficiency, and this foreclosure sale was in 2017. It's been 8 years.
I didn't see where they said, there's several places they say we're not seeking a deficiency at this time. But I didn't see anywhere, and maybe I just missed it, where they said we're never going to seek a deficiency. If that's in there, please show me where it is. Because
I can't point you to that language, but I think it's been 8 years since the foreclosure sale. In a number of appellant briefs, it's been stated that plaintiff is not seeking a deficiency judgment. I'll represent to you before the court today that they're not seeking a deficiency judgment.
Was there a deficiency, or is there just one being forgiven?
There is a deficiency post-foreclosure sale, but they're not seeking a deficiency
Trust is not seeking.
Correct.
And you're bound by that.
Correct.
You're representing that you're never going to seek it. Your client's never going to seek this deficiency?
On this loan, on this property against this defendant?
On this
yes.
loan, this loan.
Yes.
So it says plus costs and reasonable attorney's fees. Would Mr. Morris, if he were to prevail, would he be entitled to it?
If Mr. Morris were to prevail, although foreclosure, keep in mind, this is the eviction, this is the summary proceeding,
right,
8 years after the foreclosure sale. So if he were to be successful in the foreclosure, you'd have to somehow go back in time and unwind the foreclosure to be successful.
We do that in the appellate courts all the time.
I know, it's been 8 years though. I mean, again, if we keep every hypothetical open for eternity, then that's a change in the law.
I don't know why the foreclosure needs to be at issue. It seems like the SJC is saying that Mr. Morris can come and can sue your client for the deficiency. Succeeding in that doesn't get him anything other than the deficiency counts, because he'd owe the money to the bank anyhow. But he also gets to have his costs and attorney's fees in doing that, which would be some additional money he might walk off with, or at least get you to pay his attorneys. Why doesn't he have the right to do that?
Because I think that's applicable in a foreclosure setting, not the summary proceeding where we are now. Generally, the mortgages say, and the case law says, the succeeding party in the foreclosure is entitled to reasonable attorney's fees. We're 8 years post foreclosure.
But if you can't seek that in this context, why did the SJC remand for him to seek that in this context? I mean, I don't know what I'm supposed to do with that. It seems like inconsistent with what the SJC has remanded for.
That's fair, but also this issue was then briefed on summary judgment, this specific counterclaim, and there was no, I mean, you're raising some interesting points here, but it's not, we're here to kind of evaluate the record, and there's nothing in the summary judgment on this point. In fact, defendant more or less conceded this point because we all agree the plaintiff's not seeking any monetary damages.
Well, I looked at what was filed in the post-remand memo, and it seems to make exactly what I'm saying here, that they can proceed, and if they win, they wanted a chance to ask the court to order you to allow them to purchase the home back if they won in the deficiency claim. So
Well, we're post-judgment, we're post two final judgments now in the summary proceeding, so.
Sure, but a reversed final judgment.
What was that?
But a reversed final judgment. There was a final judgment. It was at least somewhat reversed by the SJC. So
No.
No?
Well, just on this counterclaim that we're discussing.
Right. So at least part of the judgment was reversed.
Okay. But the second judgment was issued in March 2024.
Yes.
So we've again litigated the substance of the summary proceeding. The court, whether you want to call it a re-enter judgment or on that one point, has now established that plaintiff has proven his case.
Right, but we're struggling with whether that is correct. I mean, that's what the judge ruled, but did he rule that correctly? Because what he ruled seems the opposite of what the SJC said in their footnote. And then what do we do with that if the judge got it wrong as to what he was supposed to do on remand?
There's three decisions right now post-remand. We have the summary judgment decision, we have plaintiff's issuance of a request for possession, and we have the denial of the motion to reconsider. So I don't think that topic was briefed in each one, but I think that the housing court has considered it and ruled correctly. Otherwise, I don't know how you'd ever have an end to a case if post-judgment you consider the fact that down the road there might be further consideration of the substance of the case. I mean, we've had foreclosure, we've had sale, we have eviction proceeding, we've had two summary judgments, and here we are. I just don't know how the case would ever end if it was always going to be open-ended to a potential reversal.
I appreciate your representation as to HSBC not seeking to recover the deficiency, but that's just your representation in court. What can the bank do to make clear on the record that it disclaims any option of going forward in the future in a separate action to recover the deficiency? Is there a way of disclaiming that? I just don't know. How do we actually resolve that issue? Setting aside the attorney fees and costs question, how do we close out this thing and not just sort of saying your understanding is your client's not going to do it?
Is that what I'm here for? I think a couple minutes ago I was
there has to be some record in the housing court too, right? It has to be, and it clearly wasn't seeking this deficiency at the time, hasn't been seeking it in the summary process action. But how do we know that it's not going to do that in any future action? Because presumably it could if it wanted to, right? So what can you do? How do you close out that issue?
In my experience, that closes with the foreclosure action. I mean, anytime.
Does a claim for deficiency have to be brought in connection with a foreclosure matter? I just don't know if that's, I just don't know.
I don't know if I want to make that leap, like that's the letter of the law. I'm just not positive, but I know that in my experience, that's how it works. I've just never seen 8 years post foreclosure, the deficiency coming up and being pursued. It's anytime I've ever seen it has been in a foreclosure capacity, and it's just not being sought here. It's been put in every brief, every motion.
You could send us a Rule 22 letter memorializing what you've agreed to this morning.
Rule 22 letter?
Yeah.
Sure.
Saying that your client is not going to pursue a deficiency.
Yeah, you're asking me to do that post today?
Yes.
Yes, yeah, that's not a problem.
Okay.
So assuming that you do that and that's sufficient, then the question, I guess, on this issue is still, do the Morrises get to pursue fees and costs?
Well, they don't have any surviving defenses or counterclaims to do so.
It's just a remedy that's provided under 15b2, right? And 15b2 was the counterclaim that the Supreme Judicial Court said is still viable. So
Well,
you may close out the option of getting any damages to offset the deficiency, but the separate question is, are they still entitled to seek fees and costs?
but the reading of the statute is directed very much at the position of the plaintiff. It says is limited to monetary damages at the amounts required to reduce or extinguish the borrower's liability under the high cost home mortgage loan plus costs and reasonable alternative fees. It's the way it's worded. It says to borrower's liability. It doesn't speak to what borrower may be bringing in a counterclaim. So I don't think that there's a surviving cause of action by borrower against my client that would lead to those protections.
So is your argument that the fees and costs option is limited to any claim that's brought to get damage? So you essentially have to sort of establish damages to be eligible for fees and costs under this provision?
I think the borrower has other protections in that realm. I think the statute is protecting my client's ability when seeking a deficiency above and beyond the debt versus the property, if it's underwater. I don't think that, as I read the statute, that it is meant to protect the borrower. I think the borrower has other protections where they're successful in a foreclosure setting, which they were not in this case 8 years ago.
But is that what the SJC held? I mean, the SJC held that they can bring this counterclaim.
I mean, that's what we held, but we got reversed.
Right.
It's not that I disagree with you, but we're kind of stuck with what the
your
SJC
position
says.
was what we held.
I know, I get it. I agree with you guys. I agree with your honors. And I don't even think it's relevant because I don't think we have the setting of a live counterclaim where this could be applied. Can I just, I know I have under a minute here, just wrap up, unless your honors have other questions.
Go right ahead.
We've obviously focused on one targeted issue. I will just say the other issues raised in the brief are either red herrings or already adjudicated by this court in 2021. A number of them are raised for the first time in the appeal setting. The rescript, the subject matter jurisdiction was already adjudicated in 2021. This court held that the housing court is appropriate for the eviction action. Look, this is this case, again, 17 years of unpaid mortgage. It's time for this motion practice and constant. There's another appeal coming. The appellant has already filed another one.
Yeah, that's the 25P 1130. Is that the appeal of the unremoval of the Superior Court's failure to accept the removal? Is that what that is? No, go ahead. Yeah,
Okay, correct.
Okay.
So that's, I believe, an extension was granted until some point in December. So we have another appeal coming. This is just enough's enough. It really is. This should be the end of the line.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Morris. We'll take this under advisement.
All right.
In this appeals court hearing, an elderly homeowner challenged a foreclosure-related ruling, arguing that health and disability issues affected his ability to present his case. The judges closely questioned both sides about a prior Supreme Judicial Court decision, attorney fees, and whether the bank could still pursue a loan deficiency. After hearing arguments, the court took the case under advisement and will issue its decision at a later date. Thanks for watching.